Thank you all for bearing with us. We are so thrilled to have so many in the audience today. My name is Kristen McMahon, and I have the pleasure of serving as the president of the Robert H. Jackson Center. I'm going to, at the outset, a couple of housekeeping items. Please make sure your phones are on silent. I know that you think that they are. I promise you they are not, so please check. For the lawyers in the crowd, you should have received an email yesterday from Mary Keating at Phillips Lytle with the packet for today's program. If you did not receive it, that means we do not have an email for you, so we will need one of those in order to send it to you. And then the information that you should have received when you checked in as well, your evaluation form and your attendance form, also remember to turn those in at the end of the day. For those in the crowd who are not lawyers, if you are interested in that packet of information, and it's a good one, it has a brief written by one of Phillips Lytle's summer law students. It also has some copies of the historical document, as well as a virtual copy of the Justice Deferred booklet that is outside. Also, just give us an email and we will happily send it to you. All right, to thank our sponsors. Today's program is sponsored by Phillips Lytle, the Randall J. Sweeney Education Fund at the Chautauqua Region Community Foundation, Chautauqua Abstract Company, the Robert H. Jackson Center Inns of Court, the Jamestown Bar Association, and the American Board of Trial Advocates. And we'd also like to thank the Chautauqua County Historical Society for the loan of some of the Albion Tourget documents that were outside our theater doors. So today, we are hosting you as part of our Constitution Day celebrations. Constitution Day itself is September 17th. And does anyone know why that is? Students, I'm looking at you. All right, so on September 17th, 1787, 39 delegates to the Constitutional Convention met for the last time to sign their names to the Constitution. In the 50s, it started being celebrated as I Am an American Day, and then it was changed to Constitution Day, and in 2004, it became, well, I'll get to that in a little bit. Article 3, Section 1 of the Constitution says that the judicial power of the United States shall be vested in one Supreme Court and other inferior courts as Congress deems necessary. And Article 3, Section 2 says the judicial power of the courts extends to all cases arising under this Constitution. And that's really part of how we get to here today. So as I was preparing for today's program, one of the things I learned was just how deep New York State's history is tied to the issue of slavery. As you came in this morning, you saw the panels from the Lemon slave case, which came to the New York courts initially in 1852. 40 years later, we have the Supreme Court case that is the focus of today's program, Plessy v. Ferguson. One of Homer Plessy's attorneys was Albion Tourget, who lived in Mayville, New York, and is buried in Mayville, New York. And about 10 years after the Plessy v. Ferguson case, W.E.B. Du Bois called on a group of men to gather for two purposes. The first was for aggressive action on the part of men who believed in Negro freedom and growth. And the second was to oppose the present methods of strangling honest criticism, something that I think we're becoming more and more familiar with today as well. This group hoped to meet in Buffalo, New York, but no place there would accommodate them. So they moved across the river into Canada, and they adopted a constitution and bylaws, formed committees, and wrote a declaration of principles. And this is the start of the Niagara Movement, which was the forerunner of the NAACP, whose lawyers took a case to the Supreme Court in the early 1950s that overturned Plessy v. Ferguson. And this history is also very closely tied with Justice Robert H. Jackson's history. He was born 4 years after the Plessy decision, and one of his final cases on the court was the opinion that overturned the Plessy ruling, Brown v. Board of Education. Now, I shortened something in my introduction. So the full name of the day we are celebrating is Constitution and Citizenship Day. Jackson gave a speech a few months after he took his seat on the US Supreme Court entitled Statecraft Under a Written Constitution. And let's break that down just very quickly. What is meant by statecraft? Statecraft is the ability to be an effective political leader, and it covers all actions that contribute to governing a state or a nation and conducting the work that is required. Jackson said, "No citizenship in the world today imposes upon its members a burden of watchfulness and understanding greater than does the citizenship of the United States." Now, Justice Robert H. Jackson had a great amount of respect for the Constitution, and he considered it a living, breathing document. And he also believed that there was immense importance that the public have a deep understanding of how government operates. Because if future generations do not master that, they will make important decisions without a solid foundation. And so for you students, he had a wish for you. Statecraft is America's youth for the taking. There is no reason why they should delay a single day in contributing their part to public opinion. So I will say to the students in the crowd, when you see something you want to change, figure out how to change it. Talk to people, do the research, look at it, challenge it. This is all part of what it is for you to do as well. So I am pleased to introduce our featured guests for today. Keith M. Plessy is a New Orleans native and is the great-grandson of Gustav Plessy, Homer Plessy's first cousin. Homer Plessy is the named petitioner in Plessy v. Ferguson. He is the co-founder and president of the Plessy and Ferguson Foundation. Phoebe Ferguson is also a native of New Orleans and the great-great-granddaughter of Judge John Howard Ferguson, the named respondent in the case. And in 2009, they co-founded the Plessy and Ferguson Foundation, where Ms. Ferguson serves as the foundation's executive director. Mr. Plessy attended an historic Black elementary school in the 7th Ward of New Orleans, and it was where he discovered his connection with Homer Plessy and his love of drawing. He went to high school at John McDonough and New Orleans Center for Creative Arts, where he graduated in 1976. And in 1979, his alma mater requested that he return to his former elementary school to make the hallways a daily reminder that education leads to great futures. And for that project, Mr. Plessy painted more than 100 images of famous African Americans, including many civil rights icons. That effort sparked a lifelong interest in civil rights history and the role of his ancestors' fight for equality. He takes great pride in sharing the remarkable history of Homer Plessy and the Citizens Committee and their efforts to end segregation laws in the South. He is also a great ambassador of New Orleans history and culture and has been a 40-plus year employee of the New Orleans Marriott Hotel. Prior to her nonprofit work, Ms. Ferguson worked as a professional photographer in New York City for 18 years. In 2001, she went to NYU to study sociology and documentary film. And in 2003, she returned to New Orleans to make A Member of the Club, a feature documentary about New Orleans' oldest Black debutante society and the rise of the Black middle class from 1895 to 2005. Ms. Ferguson moved her business from New York to New Orleans in 2006, and now operating as Bayou and Me Media Productions, she produces videos on the history and culture of New Orleans and social justice areas. Her particular area of focus in both her media work and her work at the foundation is education equity. Ms. Ferguson, along with the other members of the foundation, have been actively involved in community and legislative efforts to stop the privatization of public education in New Orleans after Hurricane Katrina. And in 2006, Ms. Ferguson began documenting the process of implementing the country's first all-charter school system from the perspective of the families, teachers, and students, which resulted in a perfect storm, the takeover of New Orleans public schools, which is an ongoing video series. And today's panel will be moderated by Greg Peterson, one of the Jackson Center's co-founders and of counsel with the law firm of Phillips Lytle. Before we bring our panelists to the table, we're going to start with a short introductory video. So Ed, if you please. Come on, guys. It's not like you've never had technical difficulties. Get a grip. All right, so we're going to have Greg and Keith and Phoebe start, and we will cue up the video when we figured that part out. So Greg, Keith, and Phoebe, if you would join us at the table, please.
How did this happen? How did we gather together today on Constitution Day with the descendants of one of the foremost Supreme Court cases in the history of the United States? Because if there was no Plessy versus Ferguson, there would be no Brown versus Board of Education. And how did this happen? I was reading the New York Times, and it talked about the Louisiana legislature authorizing the governor of Louisiana to execute a posthumous pardon of Homer Plessy. Now, in the law business, Plessy versus Ferguson is a known commodity. And there in the article was references to quotes from somebody named Keith Plessy and somebody named Phoebe Ferguson. I go, I bet they might have a number. So the beauty of Google is all of a sudden, boom, Phoebe's number appears. She made the mistake of answering. And here we are a few months later gathering together. So what you were seeing behind us here was the actual ceremony in January 5th, 2022 in Louisiana, whereby the governor was signing the posthumous pardon of Homer Plessy's conviction, a conviction where he pled guilty to violating the Separate Car Act And this, in fact, was the pardoning of that aspect. And what you have here is the district attorney, I believe, setting the scene, a very 5-minute articulation of it all, which was a perfect setup. And what was fascinating to me was this ceremony brought to light not only Plessy versus Ferguson, but also Plessy and Ferguson. So just curious, Phoebe, you first, how did you even know that that was running its way through the legislature, that maybe something you guys, the two of you started in 2007, may find this kind of attention? Might have to get a little closer.
You're talking about the,
Pardon, yeah.
well, actually, we helped instigate it. So we were approached by a civil rights lawyer in New Orleans who was reading, again, this book that brought us together called We as Free Men, Plessy versus Ferguson. And that book was written by a local historian. And, you want me to go on?
Yeah, sure.
Okay. And what was great, his name is Keith Weldon Medley, and he told the story from the New Orleans point of view. Anyway, she was reading that in 1897, after the decision, Homer Plessy, the prosecutors, wasn't enough that the decision was, that they lost in the Supreme Court, that they were going to go ahead and prosecute him. And that 1897, it was January 11th, 1897, so she realized that that was in January of 22 would be 125 years since he had pleaded guilty. And she wondered if we've celebrated every anniversary that's ever come up, if we'd actually celebrated that one. And I said, well, no. But she, because she worked so closely in the civil rights community, she put together in her mind that this might be an opportunity for us to approach the DA's office, because at this time, the gentleman speaking in the video, the DA, Jason Williams, is a very progressive attorney, a progressive DA attorney, and they initiated in the, when he got into office, he got the former executive director of the Innocence Project to head a civil rights division inside of the prosecutor's office with the mission of maybe not undoing past harms, but reducing past harms to the African American community that they have experienced through these decades and decades and decades of discrimination laws. And so that was the setup, and we were totally on board with approaching them, and we did so, and then they were thrilled because this case would be the most symbolic case they could use to educate the public about, redress, that there is no deadline. It's always time for justice. Even though it was 125 years ago, this still needed to happen, and this would be a profound way of reckoning with our past.
Well, maybe that's a good segue, because now it's ready.
Oh.
And this, we'll watch, we're going to turn around, just turn our chairs, sorry if you folks in the
Will
front
our
row
heads
can't see
be
it.
in the
But
way?
yeah, what we got, this is Orleans District Attorney Jason Williams.
Are we in your way?
Over a century ago, one of my Orleans district attorney predecessors prosecuted Homer Plessy's brave defiance of the Louisiana Sept Car Act of 1890. Just one of many Jim Crow laws passed by the Louisiana legislature to efforts codified white supremacy and racial segregation after the Civil War. Homer Plessy died convicted of this crime, but the legacy of Jim Crow laws lived on for generations. Lived on, that is, until a steady stream of civil disobedience by heroes standing on the shoulders of leaders like Homer Plessy risked their lives, causing so much good trouble that elected officials were forced to act. But the legacy of separate but equal still casts a shadow on all of our lives today. That shadow is clearly visible in the gross inequalities we see across this city and across this state, and I say across this country. It was important that the office that prosecuted Homer Plessy be the office to ask for his name to be pardoned. Because we all know that while Homer Plessy's actions at that time made him guilty of a crime under the law, it was really the law that was the crime. My predecessor should not have prosecuted Homer Plessy. Just because a law can be enforced or a person can be prosecuted does not mean that they should be. Slavery was lawful for 250 years in this country. The late Archbishop Desmond Tutu said, "True reconciliation exposes the awfulness, the abuse, the hurt, the truth." It is a risky undertaking, but in the end it is worthwhile. Because in the end, only an honest confrontation with reality can bring real healing. And although our great country has slow walked its reckoning, the office of the DA will not. America has never had a process of truth and reconciliation, an honest confrontation with the reality of its oppressive past. And we see the direct consequences of this failure to have an honest conversation so boldly in the criminal legal system, most notably with the grossly disproportionate criminalization and incarceration of African Americans. The Orleans Parish District Attorney's Office is now working openly and transparently towards confronting those dire consequences. But while we seek to correct the sins of the past, we must acknowledge my predecessor's roles in committing these sins, if for no other reason than to build the public's trust in our legal system. We must reckon with our past. We must confront. We must acknowledge. And we must humbly ask for forgiveness for the role our legal institutions have played in the apartheid that the people of this country have endured. Let me be clear. Homer Plessy was no criminal. He was then and he is now a hero. And we will do our part to ensure that history reflects just that. Homer Plessy, Louis Martinet, Albion Toujé, and the Citizens Committee belong to a long line of heroic civil disobedience that Dr. King traced all the way back to the early Christians defying unjust Roman laws. The state of Louisiana prosecuted Homer Plessy to make a point of upholding a racist law. And just as these trains are weighing in and hissing the same way they did when he boarded that train, today we make a very, very different point. We now ask our governor, Governor John Bell Edwards, to pardon Homer Plessy from the stain of immorality on our state's history. So let me welcome our friend of New Orleans, friend of justice, our governor, John Bell Edwards.
With the stroke of his pen, Governor John Bell Edwards opens a new chapter in the legacy of Homer Adolph Plessy. This historic posthumous pardon is proof that 125 years after his conviction, the state of Louisiana recognizes and honors Plessy for his role in opening the gates of the civil rights movement of the 20th century. So quoted a guy named Keith Plessy. Keith, so you're listening to this and you're a Plessy. What's your reaction to all this?
Well, on that particular day, when the DA spoke, I described to the audience that day that my feet felt like my feet were not touching the ground, because I thought that my ancestors were actually there with me, carrying me that day. From all the research that we've done in our time, and to have the dream that we've already dreamt a long time ago, to have everybody come on board with our thought of coming together, as opposed to being Plessy versus Ferguson, we became Plessy and Ferguson. And we decided to be friends. You know, it sounds like, you know, people describe us as unlikely friends, but we are intentional friends. We intended to be friends from the very beginning when we shook hands, when we met at Keith Medley's book signing. And, you know, the tie-in with the DA's speech and what followed after with the DA's office was when we brought everything to the DA's office, they went to work right away to find ways to get Homer Plessy this pardon. And in their research, they discovered the Avery Alexander Act, which was written in 2006. And this was written for civil rights activists who were arrested in the 60s, in the 1960s. And it was named after Avery Alexander. And to give you an example of who Avery Alexander was, he once sat in City Hall cafeteria in New Orleans to protest blacks not being able to sit there and eat. And they were employees at City Hall. And he was dragged up the steps by the police department with his head hitting the steps as they dragged him up the steps by his feet. And he went through that and he survived that. And he sat in with many voter rights demonstrations, housing, and just generally civil rights in New Orleans. And to have his name on the act that actually gave Homer Plessy the pardon was an extreme honor to both of us.
You say what the act was.
Oh, it's the Avery Alexander Pardon Act. And it was written for those who, in the 1960s, were in the sit-ins, the freedom rides, and we have several freedom rides and sit-in survivors in New Orleans that went through those 1960s. And he wrote the Pardon Act so that they could get pardons, but they all refused. So from 2006 to 2022, nobody decided to sign up for that pardon. And it was just sitting on the books waiting for Homer Plessy, who 125 years ago committed his so-called crime of violating the separate car law. Wow. So he would be the first in Louisiana to receive the pardon under the Avery Alexander Pardon Act.
Another quote that day: "We cannot undo the wrongs of the past, but when our government officials publicly acknowledge them and take steps to legally correct them, we give hope to this generation and the next, who will continue to be on the front lines in the fight for justice and equity in America. So saith Phoebe Ferguson." What's your sense of all of this? Do you have a pardon? Your great-great-great-grandfather was the judge who actually was involved in the case and the conviction, so you were part of that. And what is you as a descendant, how do you feel about this?
I was thrilled.
Yeah.
What was I going to say? You know, when you look at the trajectory of the case, so most people that know about the case, they know about the Supreme Court part of the case. They know that it was a civil rights challenge to oppose the discriminatory law, which said that the Separate Car Act, which was written in 1890 by the Louisiana legislature, segregated blacks and whites in separate train cars traveling within the state of Louisiana. And these laws we weren't the first to pass these laws. They were happening all over the South. But when the state passed this law, there was in New Orleans a very different culture and climate than many other southern cities, and that was that we had this Creole community of highly educated men that many had been from French-speaking families and educated in Paris, but not all of them.
And women.
And women, yeah. Am I getting off track? The judge. In this case, many of those, or some of those men, 18 men that ended up comprising of the Citizens Committee, had also been a part of writing the 1868 Constitution in Louisiana. You know that in 1868, all the southern states that had seceded had to write a new constitution, which included this civil rights being granted to newly freed slaves. And so they were a part of that. So then, 30 years later, or 25 years later, and having gone through Reconstruction with integrated schools and basically granted all rights except, male suffrage came later, in 1870, and then this period of time post-Reconstruction in which all of these civil rights were removed. They were outraged by this law, and they came together to organize and to fight this separate car law, and their mission was to get it to the Supreme Court. But they had to start in New Orleans with the local district court. And Judge Ferguson was tapped to be in that court just a few months before this case happened. And so he was the first roadblock they had to get past. And so that story, we probably get into it a little bit more later. It's, this is where, when you dig a little deeper, you find out details that are quite surprising.
Well, your great-great-grandfather was from Massachusetts
Yes.
and a carpetbagger, similar
Yes.
to a guy named Albion Tourget, who we'll also talk about a little bit later. And he came down there and stayed there and became a judge. And in 1891, the legislature passed a separate car law, and I think we just briefly talk about that, which mandated, the law mandated, and this is sort of unique, mandated that equal but separate accommodations for the white and colored passenger trains in the state. So they mandated it, which didn't make anybody really happy with regard, certainly the trains.
Right.
I mean, the people who actually ran the trains were mandated to have separate cars. So this committee that you talked about, headed by Louis Martinet, And do you want to briefly talk about Louis Martinet? I don't know if either of you have a little bit of a quick bio on him, because he clearly is a major player.
Well, in terms of his relationship with Albion Tourgier
Yeah.
and with Homer Plessy personally, because I've talked to some of Martinet's relatives in California, and they mentioned the fact that I'm pretty sure that Albion Tourgier had a lot of influence in selecting Homer Plessy as the plaintiff, but also did Louis Martinet, because from the family member I heard that he was the one that talked Homer Plessy into volunteering as the plaintiff for the case. So they both had, I think, a serious influence on Homer Plessy volunteering as the plaintiff for the case.
Well, since you're Keith Plessy, talk about Homer Plessy. Who was he?
Born in, and this is something that on a lot of documentaries and so forth, and even the governor stated it wrong that day. He was born March the 17th, 1863. I have his birth certificate. So everybody says 1862. I don't even think it was a thought in his daddy's mind.
Yeah.
But anyway, they always say 1862, and it's on the tombstone. So it's really wrong, But 1863, according to his birth certificate. Born in New Orleans, and grew up in pretty much, I'd say, 1863, Abraham Lincoln signed the Emancipation Proclamation, and he was born not too long after that. I think that was January of 1863, the Emancipation Proclamation was announced, and he was born in March that year. His upbringing in New Orleans was pretty much the Reconstruction era, and in its full force when you had Union troops in New Orleans enforcing the law. So he was able to attend the same schools as white children. He was able to marry a white woman if he chose. He was a free person of color from his lineage and in his, I would say, his DNA. In 1790, his great-grandfather, his maternal great-grandfather was white. He married a free woman of color. They had children, and I would say in the 1860s, his maternal grandfather was fighting for civil rights. And in the 1870s, his stepfather, because his father died when he was very young, his stepfather was fighting for civil rights. So he was exposed to it in stages of his life growing up in New Orleans. So it was in his DNA to fight for his freedom when his rights were being taken away. So he was one of the, also he was with a group of activists who advocated for the public schools to stay open at the late stages of Reconstruction, where post-Reconstruction was about to happen and rights were being taken away. He was part of the Justice, Protective and Educational Social Club, and that sounds like a little club that got together and had parties, but they fought to have public schools open for black children when they were closing them. And he was part of that group before he became part of the Citizens Committee. Wasn't a full force member, but he was selected, as I was saying earlier, because of his activism in the community. He was selected as the plaintiff in the second case.
Well, also, I think he was selected because of his look.
Yes.
He was a,
Well, they say 7/8 white, 1/8 black. That was according to his great-grandmother, and it's a long story, so I'll just state that she had her freedom granted to her by the governor of Louisiana in 1779. So that's how they became free people of color, from her purchasing her freedom under Spanish colonial rule in 1779. And the governor of the state of Louisiana, which was the Louisiana Territory, which stretched all the way up to Canada at the time. It wasn't part of the Union. But just recently, they've been included in the American Revolution, sons and daughters of the American Revolution, as they helped Washington win the war in the American Revolution. And Homer Plessy's great-grandmother and great-grandfather were part on his mother's side of his family. They were part of the American Revolution.
interestingly enough, and Stephen Luxembourg in his book did a little research and did the census. In 1880, Homer Plessy in describing what he was, at the time, they could put an M for mulatto.
Yeah.
In 1900, it was B, black. 1910, B, black. 1920, he puts W, white.
Yes.
Because he's I guess the term's an octoroon, is there 1/8 black? And yet that becomes a pivotal part of the arguments that go into the Supreme Court is the definition of race, of which Louisiana did not have, though they were trying to enforce race.
Well, I can tell you, in my family, there were several Plessys who changed their names because they appeared to be white, and they were able to vote because the voting rights were taken away. That's how you were able to be on the census as a voter.
Yeah.
And that's why he
And, you know, and it was strange in his case because he never changed the last name, and he was involved in the case. So it would seem as though he would be a target, and he wouldn't be able to vote, but he was able to cross over. And I was talking to someone this morning, and they said that Albion Torjee was a member of the Scottish Rites Masons. So was Homer Plessy.
Well, let me just tie this all together in a perfect world, because this particular facility that we are in, the Robert H. Jackson Center, in its prior iteration, was owned by the Scottish Rite Consistory, which is part of the Masons. So the Masonic celebration center were right here, where Homer Plessy was a member and Robert Jackson was a member. It's a beautiful thing.
Do they know what the Masons?
Who knew? Maybe they're all brothers.
Do you all know what the Scottish Rites Masons?
The Masonic Masons, by the way, there's actually up top there is a symbol, which is a Masonic symbol for justice. That's up there. I won't go into great detail about the Masons. You can look it up, but not now. Do not look it up now, but on the Masons. But that's an interesting, it's an interesting toy. And Phoebe just mentioned the fact that probably in 1920 he changed, and legitimately so, his designation to white because of voting. Probably that was it. So we'll go back to the case. We have the Separate Car Act, and doing a little research on Chautauqua County, Mayville, New York, has an attorney by the name of Albion Torjee. Briefly, he was a civil rights activist. He was a writer. He wrote various books which got a lot of attention, including this one called Buttons In, right here. And as a result, he was writing for a Chicago paper and wrote a letter to the Louis Martinet in 1891. It was a newspaper article writing specifically against the separate car law. He'd read it and wrote about it, which then got Martinet's attention at the committee, and then they contacted each other. And it was at that time where Albion Torjee in Mayville, New York, right up the road, Chautauqua County, was asked to participate in a potential legal case. And there's correspondence, which we will see later today, on that subject. And so he's brought in, they actually raised money for his legal fees. He turns it down. He takes no remuneration. He said he will take this case on for principle. So hence was the beginning of the introduction of Albion Torjee, a white Republican carpetbagger who was in North Carolina for many years, was a judge in North Carolina, hence became Judge Albion Torjee, and is very sympathetic of the plight of the colored, at the time was the term, in Louisiana. So do you want to kind of, do you have a sense of what happens after that to the committee, you know, how they decide and to proceed? Phoebe, if you want to do that?
Well,
Or Keith, go ahead.
The two cases,
oh,
1 and 2.
okay, short on the, okay. You want me to? Okay. What Keith's pointing out is that the other thing that's not as well known about the origin of the case in New Orleans was that the 18 members of the Citizens Committee, which Louis Martinet was one of the founders, oh my God, I tell us about where we're going?
Well,
Oh, Daniel
Let
Day-Doon.
me help you with that.
Yeah, okay.
Okay, so I'll do it briefly.
Okay.
All right, so there were two cases involved in this Plessy v. Ferguson finale. Plessy v. Ferguson being the last, but the first was
Daniel.
Daniel Day-Doon was a musician, and he was a member of the Creole Onward Brass Band and the son of Rodolphe Day-Doon, one of the Citizens Committee's founders. His case was an interstate case, and what they were attempting to see if they could change this law in Louisiana, the separate car law, by trying a case on the interstate level, which it was thrown out. And they thought for a minute that when they would challenge the intrastate law, which was written in the state of Louisiana, separate car law, that they would have to select someone similar to Daniel Day-Doon, who could appear to be white. And Homer Plessy was selected as a result, being that second case, and became the plaintiff in Plessy versus Ferguson eventually.
Yeah, and it just add a little flavor to that. The first case, they bought a ticket to go to Alabama. Hence, it was an interstate travel, and there had been decisions that, in fact, the applicability did not apply in this particular state law. So, in fact, they won.
They
They won, but they didn't want to win.
It was a federal,
Exactly, it was a fact, because
it was a federal law, which is that they couldn't regulate it on, but,
But it didn't
on
dir-
states level.
It didn't directly challenge
correct.
Louisiana.
Right.
So you
And
win,
as-
but you lose, and so
And
hence,
and as a matter of fact, that was overturned actually in Judge Ferguson's court.
really?
He threw it out because simultaneously, the federal law was that you couldn't regulate the interstate trains to say that you had to be separate.
So,
Yeah.
so now they reach out to somebody else. This is your great-uncle, or great-uncle Homer Plessy, and who looks the part. And it's literally a staged arrest. I mean, it's
Strategy.
everybody's on board.
Well, in addition, the railroad company, East Louisiana Railroad, was totally against the segregation law. And just like you were saying earlier, that it was difficult for the conductors to determine who was white, who was black, how to seat them in the separate cars and so forth. You had a business monkey wrench in there somewhere where, if somebody was going to a business appointment and somebody black showed up and there was not a separate car attached to the train, they had to wait until that train was attached so that one man could sit in one car in the back while the other passengers waited, and whatever appointments they had, they were late for.
Oh, my golly.
And
So-
it cost them $1,500 to add one car, which was a lot of money in those
So,
days.
being those elements involved, it was difficult for the railroad company to make money. So they were in the business of making money, and they wanted to sell all first-class tickets. They didn't want to sell a second-class ticket or a separate car. So they were in on the plan with the Citizens Committee, Albion Torje, and what I'm finding out more now is that Albion Torje was there from the very beginning. And I was thinking he came along later when he went to U.S. Supreme Court. But I'm learning more now today that, I just found out last night doing a lot of reading that he was involved from the very beginning and all the way through, all the way to U.S. Supreme Court.
Well, we clearly won a test case, and then, in fact, the second one, June 7th, 1892. So now we're on the 130th anniversary, sports fans, of that, if you want to be an anniversary person. Here we are. And what happens next? I mean, he literally sits down. There's a 7/8 white person, sits in a white car, and he has to be identified as not being white.
Well, the perfect thing that happened was that they had it orchestrated whereby he could be removed from that train without incident. Because in those days, right in 1891, as you mentioned earlier, when it started, there was 11 Italians that were hung in Congo Square and shot hanging from the ropes. Their case was a case that was involved with the chief of police being murdered, and there was a war in the docks between Italians and Irish. And the Irishman was the police chief, and he was murdered by, I say, a group of Irishmen. Everybody knew that. But they charged the Italians with the murder. And when they were acquitted, coming out of the jail, the mayor of New Orleans incited a riot. And I won't call it a riot, it was a massacre. And they took these guys as they were being shipped from the court, being acquitted, kidnapped them from that area, brought them out to Congo Square, hung them, and shot them from the ropes as they were hanging. Maybe one escaped out of the whole group. But that's the climate that was in Homer Plessy in 1892, a year later, decides to get on this train with the help of the Citizens Committee. So they had to orchestrate that incident to where he would be protected. You know, the bail was set. They had people helping them. The arresting officer was working with the Citizens Committee. So when they took Homer Plessy from that train on that day when he purchased the ticket, they whisked him off to central lockup and put him in jail, but they quickly got him out the very next day, and without incident. So it was orchestrated from many players, you know, the railroad company, the Citizens Committee, the lawyers, everybody was involved, and the plan worked. And the eventual thing they wanted to do was to go to U.S. Supreme Court to try this, because there were laws across the South, separate car laws that had been existing for 10 years before ours in Louisiana. So we were like 10 years after Tennessee. So these laws, they wanted to wipe them all out across the nation. So they got their day in court, but like we were saying, it was a loss. And after he lost the case, he goes and signs as guilty and pays a fine in Louisiana in the very next year. But I was thinking, you said something about football. You know, we were talking earlier about why would they not mention Plessy v. Ferguson in the obituary of Albion Torjee, in Judge Ferguson's obituary. In many instances, there was opportunity to mention the case, but it was ignored. But I was thinking football, and I mean, this year you guys are going to the Super Bowl, I think.
Yeah. How about those Bills?
But if you look back at their history, they went to the Super Bowl 4 years in a row, and nobody ever mentioned these guys for what they did. They lost 4 years in a row. But to get there 4 years in a row and not have that story told, it's almost like I feel about Homer Plessy's story. You know, I mean, it's a loss, but you look at the victory of them making it there 4 years in a row, and nobody ever talks about that. They always mention the winners. But back to history.
Well, you know, I love Keith Plessy and Phoebe Ferguson because here they play to the crowd. So how they could tie in, and even I could not figure out how Keith Plessy could tie in the Buffalo Bills and Homer Plessy and play to this crowd. It's beautiful.
Yeah, it's
it's beautiful. Nicely done.
Yeah.
So the case itself works its way now. He's arrested. He's arrested, and then kind of take it from there, Phoebe. And your dad gets, or your great-great-grandfather gets involved.
Okay. This is interesting. Can I give a little?
Sure.
So Judge Ferguson was from Martha's Vineyard, was where he grew up, right? And his family were whalers. And he decides he wants to be a lawyer, so he goes to Boston. And in those days, you could study under another lawyer in order to pass the bar. You didn't necessarily have to go to university. And so that's what he did. He studied under a lawyer named Hallett there, who at times was an abolitionist and attorney general. And anyway, he was born in 1838, and so was Albion Torjee. Albion Torjee was born in Ohio, and as I understand it, in kind of a anti-racist hotbed, his community, and so that his beliefs in equal rights was embedded in him as a very small child. Judge Ferguson, on the other hand, not so much. So he's, in the late 1850s and early 1860s, he's studying law and practicing law in Boston, and Albion Tourget, in the meantime, has joined the Union Army, gotten seriously wounded, went home, recovered, re-enlisted, back in the Union Army, gets further injured, comes back. While he's recovering, he gets married, he finishes his studies because he left, and re-enlists again. He just couldn't seem to, and he got even more seriously injured. Judge Ferguson doesn't join the Union Army at all. I don't know whether, he must have paid someone, to take his place? Wasn't that the deal?
Yep, that's the deal.
That's the deal. So now they both come down to the South in 1865. Albion Tourget goes to North Carolina and, becomes this incredible activist and then a judge, yes. And Judge Ferguson goes to New Orleans and basically hangs out his shield and becomes a lawyer. So his thing was, we can't find anything that really talks about his views on race, but he was definitely a Puritan from Boston, and he totally flipped out when he got to New Orleans and saw all this gambling and prostitution, and he was just like, no, we got to clean this up. So that became kind of his mission, and in so doing, he gets caught up with two politicians, Murphy Foster, who was then governor, and then Nichols, who, after he was governor, Murphy Foster puts him on the Louisiana as Chief Justice of the Louisiana Supreme Court. And these guys are, white supremacists, basically, throughout their lives. They want to get back to home rule. And so at the same time, they tap Judge Ferguson to fill a spot on the district court because the previous judge mysteriously disappeared shortly before that. And so these guys put Ferguson on the court, and most of his cases were, just burglaries and murder, whatever. But right away, he's hit with the first test case of Daniel Day-Dune and then Homer Plessy. And this is where the reason I brought up the parallels of the two is because, ironically, I think in some ways, even though we think about Judge Ferguson as being the villain or on the wrong side of history, when his decision upheld the separate car law as being a states' rights, the state had the right to regulate the railroads, and Homer Plessy violated their law, saying that they needed to go into a separate car. Judge Ferguson this is the moment he actually knows Homer Plessy's local lawyer, who was James Walker, and a former Confederate soldier, is defending Homer Plessy. And the strategy that Tourget and the Citizens Committee put together was to argue the case based on the 13th and 14th Amendment. And so they asked Judge Ferguson, if they would, this is how they wanted to argue the case, and so Judge Ferguson says, fine, we'll reconvene in a couple of weeks. And so they made their case, and Judge Ferguson says, you made a very good case, but Homer Plessy did violate the separate car law. And so therefore, he upheld that decision. here's the key. So, in the meantime, Albion Tourget is this incredible hero, risking his life every day. The moment where Judge Ferguson says that Homer Plessy is guilty and decides not to set a trial date was his moment of heroism, which isn't saying a lot. I mean, compared to, all these guys, Judge Ferguson was just not an activist in any way. And, but he orchestrated with James Walker to postpone the case long enough for the Citizens Committee to appeal it to the state Supreme Court. And that was how the case began to move out of the district court and up towards the Supreme Court. And that apparently, according to Mr. Luxembourg and everyone else, because they found it in Albion Tourget's papers, that he went to the district attorney and on request of the Homer Plessy's lawyer to, act in a way that this case get moved up. And so he did that.
You'll find that interesting letter. I just found it on Thursday. It was, in fact, a letter that James Walker had sent to Albion Tourget based on Albion Tourget's suggestion that the Attorney General talk to Judge Ferguson and how they were working that sort of procedural thing. And it did delay, which then created something called, and you can look it up, a writ of prohibition. And Judge Carter and/or Judge Cass will explain that in detail, because I can't, but it's a writ of prohibition, which was the actual procedure that found its way to the Louisiana Supreme Court. And they, in fact, then ruled in a way of which then opened the door. It's called then a writ of error. Writ of prohibition, writ of error, and it's the writ of error saying the Louisiana Supreme Court erred, and that was now appealed to the United States Supreme Court. So that essentially what happened, and I read also, and you'll see the letters, that it was well orchestrated, and Judge Ferguson, without changing the law, he just simply paused and just took a deep breath, and which permitted things to happen, which opened the gates to work its way to the United States Supreme Court. So he's yes, in many ways, a hero.
Well, a little hero.
Small h. Yep.
Small h. But I was going to say, I forgot. Sorry.
Walker?
Walker. Yeah, I tend to forget things when I'm talking. If I give a little backstory, then I forget my formula. I can't remember. Go ahead.
Well, anyways, then Walker and Tourget spent 4 years, orchestrating briefs, petitions, how to set up an argument before the United States Supreme Court. And we talk about race. And he used something really distinctive, race as property. That's a property you have. If you're a white person, it's a property value. And the black, it's a property value. And in this particular case, 14th Amendment, you can't lose your rights to property without due process.
Right.
14th Amendment. So he came up with this sort of novel idea saying for Homer Plessy, 1/8 black. What is he? They've treated him in this law, because of blacks and whites, if you're a black, your reputation gets skewed. It becomes less valuable. If you're a white, because you're in a white car, more valuable. So the value attached to race. And he actually had Walker spend a lot of time researching the Louisiana laws to see if there was a definition of race. Because how do you charge somebody? There's many lawyers here, and in the wild world of criminal law, there has to be a definition of what you're charged, and then all the elements of the crime.
Right.
Well, all of a sudden, they found in a great deal of research, Tourget, Walker, there was no definition anywhere of race. So that became a pivotal part of the argument that worked its way up towards the Supreme Court.
Well, and that happened too, I think, correct me if I'm wrong, but I think, their original strategy was the 13th Amendment, which by putting black people in another car, they became second-class citizens, therefore that was a badge of servitude, therefore that was, the 13th Amendment stated that you could not be, that former enslaved were free people, and therefore they couldn't be. And then on the 14th Amendment, that they had full citizenship rights, and therefore you can't regulate them to another car. But these arguments didn't work in Judge Ferguson's court. They didn't work in the Louisiana Supreme Court. They did use them in the Supreme Court, but again, the sitting justices found ways to, as they are doing today, interpret the 14th Amendment narrowly enough to say that that the state had the right to segregate the races, and it did not, and it was constitutional, not unconstitutional. And so the question of race became a key point that they were trying to say. What you're doing is asking this conductor to be, a judge and jury of passengers, of citizens riding on a train. And who could do that? I mean, so when Homer Plessy got on the train, the story, which way do you tell it? That the conductor asked Homer Plessy if he was black, or whether Plessy announced it?
Well, according to the plan, the conductor approached him and he asked him, was he a colored man? And he replied, yes, I'm a colored man. Purchased my ticket and I'm going to Covington. And he said, well, you will have to move to the car of your race if you're a colored man. Now, automatically you had, instead of somebody on another seat getting upset about it and getting into a fight with Homer Plessy, you had the arresting officer come in, C.C. Kane, who steps in and immediately grabs Homer Plessy and said, you got to move. Mm-hmm. And he gets him out of the train before a commotion happens on the train because you had other passengers.
Yeah.
So that's how it was orchestrated in a way where he wouldn't have any conflict with anybody. Mm-hmm. And when he purchased the ticket office, when he went to the desk, purchased the ticket, they were waiting for him. They knew it was him when he got there. So they just sold him the ticket, no dispute.
And when it came before Judge Ferguson, I remember he said that nowhere in their argument did they say that the second car was unequal to the first class car. And therefore, he said that Homer Plessy was just doing as he pleased when he violated it.
Well, the law itself to say that to promote the comfort of passengers. Mm-hmm. Which passenger are you talking about? Then you're separated by white and black, but which passengers are having comfort and which ones are not?
Right.
But
right.
That was the law. That's the way it was written.
And what I was going to say before was that, so when Judge Ferguson agreed to working with them to do the delay, he had to have realized that if they got past the state court, that they would actually challenge it on a writ of error to the Supreme Court, which would make him the defendant.
Right.
And so therefore, he was putting himself, the case would become Plessy versus Ferguson. So for someone who was almost an introvert and stayed out of politics, race politics, I think that was interesting that he had to think. I mean, I didn't think about this for a long time, but it finally occurs to me, wait a minute. He must have known this was going to happen, and this was going to be a big case.
Yeah, the case, the way it was styled, and I'm looking at Judge Carter over there, but was styled, so there was ex parte Homer Plessy. That's how it was before Judge Ferguson. And then it was ruling, and then enter the whole writ of prohibition process, Louisiana Supreme Court. Now it's a writ of error because it's directing Judge Ferguson not to proceed with the trial.
Right.
And so that's that aspect, hence Plessy versus Ferguson. So that's how it flipped, if you will. And you're right, that's kind of an interesting, I never thought about that, but that put him in the limelight.
Right, and the question we get asked all the time is, how did it come to be called Plessy versus Ferguson? And so that's why you have to understand the progression of the case to understand that he suddenly becomes, instead of the judge, he becomes the defendant.
So they argued essentially before the Supreme Court on two aspects. This is Constitution Day. The 13th Amendment, which abolished slavery, and the 14th Amendment, which we'll get into some detail. The 13th Amendment aspect of it, the case, the way, again, back to the values, if you're black, you essentially they created a caste system, blacks, whites, and that in Tourget's world and Walker's world violated the 13th Amendment. And with regards to the 14th Amendment, the aspect of value, and there's several other details. It's a long 80-page brief, by the way. By the way, that brief is sitting in Westfield, New York. How many people from Chautauqua Lake School here? Anybody Chautauqua Lake School? A bunch of people? All right, right down the road, Westfield, are all of the papers of Albion Tourget, including his brief that we're working off of right now, the actual document itself, and the notes that he argued before the Supreme Court. But among the things he talked about, the 14th Amendment, which is the confiscation of property rights. My property right to the sustainability of life without due process, by being put into a black car, that value of race went down. And he wonderfully put in his brief that justice is pictured blind, and her daughter, the law, ought at least to be colorblind. The term colorblind, that will come up. Let me read that again. Justice is pictured blind, and her daughter, the law, ought at least to be colorblind. A critical piece of the puzzle. Now, for all of you who should, I'm going to stop.
Yeah.
Please sign up your email, because in the packet is a bunch of fascinating work done by Hurwitz and Fine, the Abota folks, talking about Plessy, and also by my firm talking about specifically the source of the term Constitution is colorblind. It goes back to 1870. I won't give you all the details because you have to read it, but it's there in the brief and in the files. We'll show that this afternoon. So that is an argument that is made by Albion Tourget. And he went on to say something really profound and sort of right to the point. Now the judges, you talked about the Supreme Court judges at the time were all pretty wealthy guys, they're all white. And he then says in his argument, suppose a member of this court, he's looking at the court, 8, as it turned out, one guy recused himself. There was 8 members. Suppose a member of this court, nay, suppose every member of it should wake tomorrow with black skin and curly hair, two obvious controlling indications of race, if so ordered by a conductor to change his seat, what humiliation, what race would then fill the judicial mind? She's looking at him in the eyes and said, what happened if you woke up by the mere accident of birth and the conductor, using his discretion, which he had complete discretion, and mandated you move? Would you think differently? Talk about difficult argument, but he did it. He looked him right in the eyes and said that. That's where Albion Tourget.
And I'm sure they had nothing to say.
Well, they said a lot in the opinion that it didn't affect them
Well,
whatsoever.
yes, right.
As the case worked its way through, do you get a sense of, back in New Orleans, there's the Citizens Committee. It starts its way through the judicial process, and that's where it should be. That's where they wanted it to be, 1892. Many years pass, like 4, till it gets to the Supreme Court. Do you get a sense in New Orleans, was the Citizens Committee, Louis Martinet, that's what I say, what they were talking about? Did they have a sense of optimism, pessimism?
Well, the makeup of the Supreme Court, the U.S. Supreme Court, was changing around that time, in that period of time that passed. So even the gentleman Nichols, who was mentioned by Phoebe as being an associate in Louisiana, was appointed to the U.S. Supreme Court around that time.
No,
wasn't
not
it?
Nichols, Edward White.
Ed White.
Ed White, yeah, Ed White,
Ed
yeah.
White, yeah. But Nichols was the governor at that time. And all those things were changing. You know, you had massacres that happened like Colfax, Mechanics Institute massacres where, you know, hundreds of black people were murdered. And Nichols had a lot to do with it.
Yeah, Murphy Foster.
Murphy Foster as well.
Was
So
good,
these were
yeah.
associates of Judge Ferguson. So throughout that time, they were experiencing a lot of violence in New Orleans, leading up to the Plessy and Ferguson case in that 4-year period.
Well, and the country was, you know, in part, even though it hadn't been reached the Supreme Court, the segregation laws were increasing, and the violence was increasing, and they became, I know Louis Martinet became very disillusioned and concerned that they would not win the case. And, but, you know, they stayed with it and made it to the Supreme Court in 1896. I mean, 1895 was, something about 1895.
Yeah, they set the case down for 1895, and then they actually argued it in.
In 1896.
1896, yeah.
Yeah.
And so they literally, on April 13th, 1896, before 8 members, David Brewer was absent, Tourget argued, a guy named Phillips, who was the hired gun by the Citizens Committee from Washington, was there, and then also a hired gun on behalf of the Louisiana was there as well. I mean, Judge Ferguson had the whole state, you know, of Louisiana. Of course, they had to protect the law. It was the law that was at issue here. And I just, probably for the sake of timing, the decision came down. It was 7-1 in favor of Judge Ferguson, and Homer Plessy lost. Homer Plessy lost. The sole dissenter was John Marshall Harlan. What was the opinion, briefly, was given by a guy named Justice Henry Billings Brown, that dealing with the 13th Amendment, separate cars had nothing to do with servitude. He just washed it away. Nothing to do with it, guys. And he went on to say, a statute which implies legal distinction between white and colored has no tendency to destroy legal equality of the two races or reestablish servitude. And he basically said Louisiana had the police power, convenience, and kind of used some very ambiguous terms that they had the power to do what they did when they passed the legislation and endorsed that particular custom. John Marshall Harlan was the dissenter. One guy dissented. And he went on to say a couple of things of note, many things of note. It's worth reading the dissent. In my opinion, the judgment will, in time, will prove to be as pernicious as the Dred Scott case of 1857. That's when it was decided that a black, by definition, was not a citizen.
Right. Are you all familiar with the Dred Scott case?
Go ahead, wait, give it a little background.
Well, that was the case where it was decided by the Supreme Court of the United States that a black man was considered to be 3/5 of a human being. And this was law.
How would you like to be considered 3/5 of a human being? Does that seem something you can relate to? Okay. So they didn't either. Go
No,
ahead.
but just on a note of victory, because we're talking about losses in U.S. Supreme Court, Dred Scott, Plessy v. Ferguson. In 1852, the state of Missouri betrayed Dred Scott and his family because there was a once free, always free law. And when Dred Scott went to another state in 1852, which started this whole process with him in the 1857 case,
Dred Scott was a slave.
and he was trying to get his freedom. He went to a state with a man who owned him previously, and he was considered free when he went to the state where it was a free state and not a slave state. Well, that freedom was short-lived. And in 1852, Missouri, the state of Missouri, turned its back on Dred Scott and his wife and sent them back to slavery. Now, I was a witness on March 26th this year. Went to St. Louis, Missouri, to witness Dred Scott's charges in Missouri State Supreme Court renounced by the legislature, by the Senate and the House, unanimously, Republican, Democrat, you name it. Everybody unanimously approved of his charges being removed. And just like you saw the DA announcing Homer Plessy's charges being removed and him receiving a pardon, same thing happened for Dred Scott on the state level. Now the 13th, 14th Amendment, and 15th Amendment were supposed to have changed the ruling in the 1857 case where he was considered 3/5 of a human. And they considered that the 13th, 14th, and 15th Amendments had removed that in a sense, but they still have to have, and I think we still have to have a day in U.S. Supreme Court where that's considered null and void.
In fact, that's a good segue to the continuation of the dissent of John Marshall Harlan, who famously said that in the view of the Constitution, he was mad, he was really mad. In the view of the Constitution, in the eye of the law, there is in this country no superior, dominant, ruling class of citizens. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. Let me repeat that. In the eye of the law, there is in this country no superior, dominant, ruling class of citizens. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. The term colorblind, interestingly enough, was argued by Albion Tourget in his brief. Is there a connection?
Oh, yes.
Is there a connection? A guy from Mayville, New York, right up the road, wrote that in Mayville, wrote those words in Mayville. And it's now become iconic in constitutional law, and Justice Marshall Harlan has subsequently been revered as a great dissenter. I'll digress for just a second, because we know the end game here is in 1954, Brown versus Board of Education, which ruled that Plessy versus Ferguson is no longer the law. No longer the law.
It
And-
overruled it.
It overruled it, and Robert Jackson, our guy, was part of that court. And I will go into maybe some detail later if time permits, but what was interesting, and I didn't know this, the New York Times in blazing headlines in a big editorial said, Justice Harlan concurs. Justice Harlan concurs on Brown versus Board. Because of what he said, many years earlier in Plessy versus Ferguson, which is just a fascinating how time gives the benefit of a dissenter's view, and it goes towards exactly what our earlier District Attorney Jason Williams talked about. You know, if you have a feeling, feel it. Kristen McMahon talked about that earlier today for students, and that's a really credible object lesson. So Homer Plessy, unfortunately, loses in 1896. Do you have any sense at all what his reaction might have been? Do you have any history that, you know, I realize that's not what you wanted to have happen, but nevertheless, within the family, has anybody ever got a sense, did it bother him? I mean, you know, what was the reaction?
Well, it's kind of tough because our history is not accounted for as much as, you know, the history of those folks that won the case in that time. And maybe even Judge Ferguson on his obituary, you know, you had a little bit of attention there. But when Homer Plessy died, it was like just a blank thing almost in the paper.
Actually, it wasn't mentioned in Ferguson's obit,
Not at all.
not at all.
Yeah. But back to the family, we never discussed it at the kitchen table when I was growing up. We never discussed the case. I have a biology professor at University of Virginia who probably could have been the voice of our history, but he never pursued it. And here I come along many years after he passed through the colleges and so forth. And I'm a bellman at the Marriott for some 40-some years. And in 1996, when I think your author, Elliott?
Yep, Mark Elliott.
Mark Elliott. In 1996, I get introduced to the case by Mr. Medley. And from there, I'm totally interested in finding out about my ancestor. And eventually, we meet through his book. Mm-hmm. And I'm chosen as the one to tell the story now.
Yeah.
So it's kind of humbling. It's humbling because I get some calls from some of my family members at times. Those that kept telling me in the beginning, "What are you doing, man? That's just history." You know, you keep talking about that same thing. You know, even my daughters kind of doubted. You know, when we started talking about the case and trying to get the recognition for the Citizens Committee that they deserved. You know, my family didn't go along with it too much. But now I think when the governor signed that pardon, I think it got their attention.
Now, but along the way, you did meet some civil rights activists, didn't you?
Oh, wow. And I can attest to the Marriott being the place where I met him. Muhammad Ali, for the second time I met in the Marriott. And the biggest person I could say that I ever met, who actually gave me she probably put a sword on my shoulder and sent me on my way to do the work.
Give you marching orders.
Rosa Parks. And
Not everybody meets Rosa Parks, so talk about that a little bit.
yeah, well, I'm at work in 1996, and 1997 rolls around, and they had the case. They had a big gathering in New Orleans with all the people from around the United States recognizing the case in 1996.
Because
It was the anniversary, the 100th anniversary of the case. And they did a mock trial for the U.S. Supreme Court case. You had all the people there, John Hope Franklin, Constance Baker Motley, all the people with the NAACP were there. And I made some of the events, but that very next year, I'm working and all my coworkers were referring to me as Plessy versus Ferguson. I wasn't Keith anymore. So one of the guys says, "Hey man, you know, Rosa Parks wants to meet you." And I said, "Come on, man, why you doing this to me? You know, I mean, every day I'm hearing Plessy versus Ferguson. Can I just be Keith?" So he said, No. Rosa Parks is in the GM suite, and I told her your name, and she wants to meet you. So I said, well, okay. So I run to the GM suite, tap on the door, and she happens to be traveling with Cicely Tyson. So that's who opens the door. I said, "Well, hi, Miss Tyson." She said, "Oh, you must be that Plessy boy." So I said, "Well, yeah." So I walked to the back of the room, and Rosa Parks is sitting in this big chair. And I automatically, because that's my idol. You know, she did what my ancestor did a long time ago, and I idolized the woman. She was considered the mother of the civil rights movement, the modern civil rights movement. So when I kneeled on one knee and said, "Thank you, my queen, for all your hard work," she said, "Get up, boy, your name is Plessy. You got work to do." I can tell you, I didn't get it then. I really didn't get it then. I was too shocked. I didn't ask for an autograph. I didn't say, "Can we take a picture?" Nothing. I was blank. So, you know, she gave me a rose, and I tried to preserve the rose for like 2 years. It crumbled, and I have it in the paper, and it just went away. But she died during Hurricane Katrina, when we were displaced, and I was in Memphis at the time. I was working at the Marriott there. So there was a guy that came by, and he had the obituary, the original. And I said, "Man, could you make me a copy of that?" So he makes the copy, I get the copy, and I'm back, eventually back 2006. That happened in 2005. 2006, I'm back in New Orleans. And I'm in the lobby, and this lady comes in, and I asked her, "Where are you from?" She said, "Oh, I'm from Montgomery, Alabama." So her name was Miss English. She was working in the church at the time in Montgomery. And I said, "Well, I have a photocopy of Rosa Parks' obituary." And she said, "Really?" I said, "Yes, ma'am. I'll make a copy for you." She said, "Son, Rosa Parks is my best friend. I have the original for you." So I have the original of her obituary. At my
I
house.
didn't know
One of my
that.
friends.
It's a good thing you showed up.
Right. Just went back to work normal. And there you go.
That's got to go
Back
in
in
the
the Marriott.
archives, I think, doesn't it?
Well, there's a perfect way to kind of get our way towards winding and get these guys back to class. But Rosa Parks exhorts you, get on with the business. What is the business now of Plessy and Ferguson? We know you met through autograph signing, book session with Keith Medley, and next thing you know, and so what's the mission here? Give us a charge.
Well, our mission is, you know, on the one hand, is to honor the work of the Citizens Committee and their courage and fortitude to take this case to the Supreme Court. And we do that by teaching the history of the case and why it's still important today. And you can, if you're following the news, you can understand with the attempt at reinstituting voter suppression laws and over-incarceration and, you know, even using, overturning Roe, using Plessy to overturn Roe, brings us into, the case stays in the contemporary discussion about equality. So we do this in a few ways. We do what we're doing right now, talking to students all around the country, and we put up historic markers. One of the first things that we did, between the time we met and the time we founded the foundation was about 5 years, and we wanted to create in New Orleans a trail of monuments and honoring the work of African Americans in the city, the achievement and the resistance, and so that it would be a visible understanding of the existence and the, you know, who really created New Orleans to be what it is, and who obviously the economy was based on slave labor. But there were nothing to, for people coming to the city, how would they know? So we put up historic markers, and the first one was the Plessy v. Ferguson case, and that was unveiled on the day that we announced that we would become a foundation. And since then, we've put up another 4 markers that honor
Well,
Keith's
take it from there.
elementary school. Yeah.
I would say one of the most successful markers that we put up is evidence in a school building called now the Sept Center, representative of Tate, Etienne, and Prevost. Now, everybody knows the Rosa Parks, I'm not Rosa Parks, I'm sorry, it's, Ruby Bridges story. Everybody knows about Ruby Bridges?
What do you know about Ruby Bridges?
But desegregation of public schools in the South, and a 6-year-old girl going into a William France elementary school for the first time in 1960. Well, her story is a Disney movie. There's a book, but there were 4 girls who was involved in that case. It's called Earl Benjamin Bush versus Orleans Parish School Board. And to show you how stubborn the Louisiana legislature was, that case was filed before Brown in 1952. And Earl Benjamin Bush was too old to go to elementary school by the time the case was recognized. Brown was decided in 1954. In 1960, 6 years had gone by in Earl Benjamin Bush's life, so he wasn't an elementary school student anymore. And they had to select 4 girls to integrate the public schools at the time. And just to show you how rough it was there, it would be more safe for them to select 4 girls than 4 boys, because there was this myth that boys would attack your white daughters and you would have a problem. So they had 4 little girls to integrate the public schools. 2 schools, William France, Ruby Bridges by herself, and 3 girls, Leona Tate, Gail Etienne, and Tessie Prevost, integrated McDonough 19. Now, by that one story coming out about Ruby Bridges, you would think that that was the only person, the only girl that integrated the public schools. But neglecting those other 3 girls, it kind of nullifies the case itself. And what we wanted to do, when we came out of the gate, Keith Medley was a big influence on this, an author of the book We Is Free Men. We wanted to recognize those 3 girls and the school they went to. So by the time we, in 2010, found the school almost ready to be hit by a wrecking ball, we had to go and put that marker up before the school board tore the school down. And we advocated, we got everything going. We worked with the Leona Tate Foundation for Change, which is one of the girls who now runs the Sept Center. But in 2010, we stopped them from tearing the school down. And over the period that went by, over about 11 years, 10 years or so, Leona Tate never gave up the fight. And her foundation, Leona Tate Foundation for Change, now houses the school that's been renovated with over $16 million to maybe $20 million to get the school refurbished. And they've taken the first floor of the school and turned it into an interpretive center. And they'll deal with anti-racism. They have a group called
People's Institute.
People's Institute for Survival and Beyond, who'll be housed in that area on the first floor. And on the top 2 floors of that school building is 25 elderly, affordable living spaces. So you're taking care of the elderly, you're taking care of the young, out of a center where racism refused them to be students, is now a shrine to peace. So,
He's just saying that, you know.
and now the marker started that process.
Right, exactly.
And talking about marker, I am looking at and Plessy and Ferguson Foundation together. The importance of acknowledging the complicated past when building a stronger future. An inspiring response to the separate but equal Supreme Court decision of Plessy versus Ferguson. We have been blessed today, ladies and gentlemen, to have in our presence Plessy and Ferguson. So to Keith Plessy and to Phoebe Ferguson, many thanks.
Thank you all very much for joining us today. I also, in the spirit of giving credit where credit is due, I misspoke in my introduction, and the brief that is in the electronic packet was actually put together by one of Hurwitz and Fine's law clerks, Tabitha Salonen, and so just wanted to make sure I gave that credit where that credit was due, because that was an awful lot of work for her. So otherwise, students, thank you very much for being with us today. Some of your buses are already outside. I know some of you are sticking around a little bit longer, and so for those of you joining us for lunch, we will be downstairs. Thank you very much.
Thanks, everybody.
That was wonderful. Of course, yeah, thank you very much. Yeah.
I really want to know, I wish I kept that folder because pictures.
No, I mean, yeah,
Just have the teachers know.
yes, absolutely, yeah, and we'll share, because we have shared the foundation's website.
Called a special meeting of the Jamestown Bar Association together. Kristen Lee Yaw has waived her right to take the podium. We've waived reading of the minutes, secretarial minutes. We've waived the treasurer's report. We've waived everything right up to the event. So on behalf of the Jamestown Bar Association, all those in favor say aye. Aye. Good job, that's a way to work a meeting. And now we are at the program itself. Thank you, everybody. Thank you for the Jamestown Bar Association for hosting this special meeting. Thank you for our special guests from Abota. We got the cream of the crop right here at this particular table. And for all the sponsors who made this all a reality. What a day, what a morning with Plessy and Ferguson. And the fact of the matter that pivotal and part of that is Judge Albion Tourget from Mayville, New York. And that story relating to Tourget, Plessy, Ferguson is a special one. Extra special is the fact that we have today, to underscore the importance of this day, our special guest, Judge Kevin Carter. But that wouldn't have happened without the intercession of our Robert H. Jackson Center board member, surrogate court judge, jack of all trades, Mr. the Honorable Stephen Cass. So to introduce our special guest is our special friend, the Honorable Stephen Cass. Judge Cass.
So, first of all, I'd like to thank you all for coming, and Greg, I don't know how you do it. Putting something together like today, tying it into Mayville, Tourget, Buffalo Bills, everything.
I didn't do the bill, that was Keith, good job.
But I have to tell you, it's a great honor to be here together with you attorneys. We have a proud profession, and I'm proud to be an attorney and a judge, and thankful that you're all here. It's a great honor to introduce Judge Carter, and in the future I'll be able to say he needs no introduction. But today I'd like to spend a little bit more time kind of going through some of his accolades, because he's really quite a guy. So he graduated from Canisius College, where he still serves as an adjunct professor there. He went on to the State University of New York, Buffalo Law School. Once he got out of that, he went into the practice of family and domestic relations law. 1998, he receives the Honorable Michael Dillon Law Guardian of the Year Award. Wow, right? Judge Hanlon, wow, which means he loves kids, concerned about the community. Then in 2002, he's elected to the Erie County Family Court. Re-elected in 2012, and this year he's cross-endorsed. Wow. Out of Erie County to be cross-endorsed as the Family Court judge. In 2008, Judge Carter was designated as the acting Supreme Court Justice. 2012, Judge Carter received the Minority Bar Association of Western New York Trailblazers in recognition for courage, initiative, innovation, risk-taking, and leadership. 2018, he became the presiding judge of the Erie County Youth Bar, which has jurisdiction over felony charges for people that are kind of in between the felony, it's a second chance law. It helps our younger people get an opportunity to succeed. In 2020, he was honored with the Liberty Bell Award in recognition for his involvement and implementation of the Youth Part Raise the Age legislation. In 2019, he became the supervising judge of the family courts. And then in July of 2021, he became the administrative judge of the 8th Judicial District, where he manages really the day-to-day operations of the trial courts in all of the 8 judicial districts, or all of the 8 judicial districts, which includes Allegheny, Cattaraugus, Chautauqua, Erie, Genesee, Niagara, Orleans, Wyoming counties. Just kind of think that through. So here's a judge, family court judge, who's done so well that the Office of Court Administration and his peers decide that he should be the one leading us, leading all the judges and everybody in the 8th Judicial District. It's really quite an accolade. He's married and he has 3 very successful children. And one of the things that's interesting is his youngest daughter attends the University of South Carolina Honors College, where both my daughters went, so I have an immediate connection with him. But when I asked Judge Carter, other than your family, what of your accomplishments brings you the most satisfaction? You know what he said? Withstanding the test of time, standing up to adversity, and fighting through it. That's quite a testament to Judge Carter. Tip to lawyers. Judge Carter, what's your tip to lawyers? Both new and accomplished. Try to better yourself every day. With that, Judge C, that's what he signs his things when I get letters from him, Judge C. But Judge Kevin Carter, we're very pleased to have you. Thank you, Judge.
Good afternoon. It's good to see you all. And, you know, to be in person is a wonderful thing. I know we've gone through several years of not being able to get together like this, and it was starting to drive everybody crazy, I'll be quite honest with you. And I really understand it. I mean, I have a real firm understanding about driving people crazy, because I do it all the time. You know, I really appreciate the invitation to come here to join you today. I know Mr. Peterson and Judge Cass, they were super with me when they reached out and spoke with me about it. And, you know, and I want to say thank you to Judge Cass for that special introduction. It's very kind of you. When I spoke to Judge Cass and Mr. Peterson about joining you this afternoon, you know, after they talked to me about the Plessy Ferguson presentation, and then after we talked and chatted about the Women Slave exhibit, you know, I asked myself, and even to Judge Cass, I said, well, what more could I say? Like, what could I bring? What could I add that would be of substance and would be sufficient? You know, and as Judge Cass is always the type of guy that he makes light of some things, he has good humor, and he's just an all-around solid person. So he said to me, he said, you know, he said, Judge, you should come down and talk about your role as an administrative judge. You should talk about the road that you took to become an administrative judge. And I chuckled at that. I said, you know, it's really not that interesting. I don't know how many people would like to listen to that. And of course he said, well, you know, Mr. Peterson, this is a CLE course, so don't worry, they'll listen. I said, okay. So I was happy to hear that. And then the other thing that Judge Cass would say and said during this conversation, he said, don't worry, just make it brief. And he kept saying, make it brief. And then he would say, be brief. And brief is a good way to go. And I'm like, okay, I got it, so I'll be brief. I'll be very brief. Now, you know, one of the things I wanted to point out before I even talk about myself, which quite frankly I don't enjoy doing, but I did come down and I listened from start to finish to the Plessy Ferguson presentation, and I am in awe. It was incredible. I learned some things I had not known, and of course, how could I? It was very personal, and it was just awesome from my standpoint. I hope you all were able to listen to that. It has a lot of substance, and it was just truly awesome. And I think you'll say the same about the Lemon Slave exhibit, as well as the film that we're going to show you in a moment. The point of the Lemon Slave exhibit is to really show that New York State historically was ahead of the curve when it came to the ideology about the ills of slavery, okay? The Historical Society of the New York Courts was founded in 2002 by then Chief Judge Judith Kaye, Chief Judge of the Court of Appeals. The mission of the Historical Society is to preserve, protect, and promote the legal history of New York, including the heritage of the courts and the development of the rule of law. Now, the Lemon Slave case is a clear example of that, okay? We learned earlier about Plessy, which has a lot to do with Louisiana, and now you'll hear a little bit about the Lemon Slave case, which has everything to do with New York State and the concept of handling slavery. In 1817, New York State passed its first law stating that all enslaved people in New York State were freed as of July 4, 1827. In 1852, a freedom suit was started by way of petition, a writ of habeas corpus filed by Louis Napoleon before Justice Elijah Payne. The record, when it talks about Louis Napoleon, merely refers to him as a colored man. He was not educated. He was illiterate. But he was smart enough to hire or to find John Jay to handle the case for him. The case goes in before Justice Payne. The case highlights the role of New York played in freeing the slaves, because Justice Payne had before him an enslaved mother and her children and a number of other slaves who were traveling from Virginia with their slave owners, the Lemon family, on their way to Texas. And, of course, young Mr. Napoleon, who was an abolitionist, couldn't read or write, but he was an abolitionist. He knew what was right. He filed the writ. The case goes into court. And Justice Payne essentially ruled that, look, you did not have to come through New York State to go to Texas, but you did. And because you did that, you must comply with the laws of the state of New York. And our law was that slaves were freed in 1827. So as a result, your slaves will be free as of this day. Now, you know, Justice Payne was a pretty smart guy, but it wasn't just the law that he was citing. It was his personal belief that slavery was improper, that we just should not have it. In 1860, after numerous appeals, the case goes to the Court of Appeals in New York State, and by a 5-3 vote, they affirmed Justice Payne and held that slaves were freed. Now, the ruling is in direct conflict with the 1857 Supreme Court Dred Scott decision, which held that colored people were not U.S. citizens and thus could not expect any protection from the government and or its courts. And of course, here it is, we have enslaved individuals going into a court of law and having a judge at that time, you know, issuing a ruling. And then in 1860, our Court of Appeals, notwithstanding Dred Scott, said no, they do have protection of the law, and they do have and should have the benefit of the courts. The Lemon family subsequently tried to file an appeal with the United States Supreme Court. Well, by that time, the Civil War had started, and of course, Virginia was no longer part of the Union, and their appeal fell short. The irony of this case, which is a small irony, but it is an irony in my mind, is that these children who were freed in New York on their way to Texas, had they gone to Texas, these children, to this day, as you sit and a few of us stand, Texas viewed children as a possessory interest. So even in 2022, they're not looking at them the way that I look at children, as human beings and not property. So while New York was ahead of the curve as it relates to slavery as it related to slavery from an ideological perspective, it unfortunately had a rich history of discrimination, denial of human rights, denial of civil rights, constant rejection, and even segregation that in large part was the result of decisions like Plessy versus Ferguson, as well as an unwavering hatred of colored people. And of course, earlier today, we talked about and listened to the talk about Plessy v. Ferguson. You all know that decision was decided May 18, 1896, and it essentially held that racial segregation laws did not violate the United States Constitution, so long as the facilities for each race were equal in quality. And this is 1896, and so I don't need to tell you that that was utterly impossible. Utterly impossible. As it is, as we currently sit and stand today in 2022. And of course, that's a conversation for another day. It would take a whole series of lunch hours to talk about the economy and the impact that it has on race relations. And so, of course, we have witnessed positive change through the years. You know, the history is what it is, but we had freedom fighters of all shapes, sizes, and colors, without which we would never have change. But we do have freedom fighters, okay? And we have a couple of freedom fighters with us today, and Mr. Plessy and Ms. Ferguson, and I'm thrilled that they're with us and they joined us. And they gave an awesome presentation, and I'll keep saying it because I believe it to be true. So we've seen this change, we've witnessed it through the years, not only through individual freedom fighters, but through movements such as the suffrage movement, which we don't talk about a lot, but we should, okay? Movements like the Civil Rights Movement that produced Brown versus Topeka Board of Education in May 17, 1954. And you all know that Brown versus Board of Education, it's said that it's holding that the separate but equal doctrine was unconstitutional, essentially overturned Plessy versus Ferguson. I'm a judge, I'm a lawyer, I get to disagree. I get to disagree with that. I think it did in part, but I don't think it overturned it. If you read the decision, it says separate but equal doctrine is unconstitutional for American educational facilities and public schools. That's a limited ruling, okay? I issue rulings all the time. That is a limited one, okay? It was a quasi-overturning of Plessy by referring to the unconstitutionality of separate but equal doctrine in terms of educational facilities. Nevertheless, the decision did lead to more integration in other areas. It certainly was the beginning of true desegregation We haven't really gotten there yet, which is another subject for conversation on another lunch day, and I would love to come down and have that conversation as well. But we're on the right road. It led to subsequent decisions by the Supreme Court. In fact, you all know that there's not one Brown versus Board of Education case. There's multiple Brown versus Board of Education cases, which, by the way, just goes to my point, right? That it isn't a thorough 100% overturning of the Plessy decision. And it led to far more civil rights legislation, which ultimately is the groundwork, it is that hammer that opens the door so that we all can dine together and drink together and talk together and have fun together. It's an awesome thing, the civil rights legislation. Now, you know, all of this history had a direct impact on me. There's no question about it. It's had a direct impact on me and other people of color, the impact of which is felt to this very day. 2022, we're still talking about it. Why is that? 2022, okay? It's a direct impact on us all, but certainly on me as a man of color, all right? And this is an example of it. I'm the first and only person of color to serve as the administrative judge for the 8th Judicial District, having been appointed in 2021, first and only. History of the state of New York, the first and only. But for the 1817 law that freed enslaved human beings, but for Brown versus Board of Education, but for the civil rights movement, would not be the case. It would not be the case that Kevin Carter, an African American male, would be standing up in front of you all as the administrative judge for the 8th Judicial District. And but for the history of slavery, segregation, holdings in cases like Dred Scott and Plessy, a denial of civil and human rights, and constant rejection, it would not have taken so long. It would not have taken so long, okay? The New York State Constitution was ratified in 1846. Thereafter, the Supreme Court judicial offices were obtained through party conventions and elections. There has never been a person of color to chair any major political party in the 8th Judicial District. Never. The system, as we all know it, has produced 5 persons of color to serve on the New York State Supreme Court in the 8th Judicial District. 1 Native American and 4 African Americans. I give you this, Judge, that Governor Hochul appointed a young man who was a city court judge in Buffalo to serve as a Supreme Court judge, and he was crossing doors, so that would make it 6. In 176 years. 176 years. 6 people of color. Now, as Judge Cass pointed out, I am the administrative judge for the 8th Judicial District, which is comprised of Allegheny, Cattaraugus, Chautauqua, Erie, Niagara, Orleans, Genesee, and Wyoming. And I would be deceptive, misleading, if if I were to say to you that I'm the smartest person of color in the district. Not even close. Not even close. And yet, here I am standing here because of opportunities that I will talk to you about in a moment after we view the film, The Limit Slave Law.
Have you ever heard of the term separate but equal? Of course you have. It was the law that was in place before Brown versus Board of Education. But what's the case that brought on separate but equal? Hi, my name is Jared, and welcome to The Five, where we share 5 interesting things in Black culture and society in every episode. And don't forget to subscribe and hit that bell so you can get notified when we release new episodes. Number 1, the Separate Car Act. The Reconstruction era saw various laws that were intent on strengthening segregation. The South was especially struggling with how to interpret equal rights as stated in the Reconstruction Amendment. Legislators
Our
in
technical difficulties
Louisiana
continue.
came up with a perfect
Is this the
solution.
wrong video?
They proposed a
Yes.
Should have deleted that video.
This one runs about 40 minutes, so we probably don't want to watch it.
And while they fix that so that we don't lose you, if I haven't already done that, it turns out that the film is about 12 minutes. So, it won't run too long.
Forget it. Judge Carter, could you help those of us who are not lawyers understand what an administrative judge is?
Yes, so what I plan on doing is, as soon as we have the film, I'm gonna talk to you a little bit about the role of an administrative judge. And it's kind of interesting because not many people know. Even lawyers don't know, which is interesting too.
All right, now we're set.
And if it makes the lawyers feel better, I was a judge for quite some time, and I didn't even know what the law was.
Yep, we know.
New York courts played in chipping away at the foundation of slavery before the Civil War. This is the story of the Lemon Slave Rescue. Hello, and welcome to this video presentation from the Historical Society of the New York Courts. I'm Janet DeFury, Chief Judge of the Court of Appeals of the State of New York, and I'm delighted to introduce this brief video about an inspiring court case involving some very heroic New Yorkers. The case was decided in the 1850s, just before the Civil War, and it involves the emancipation of 8 young people who were held as slaves until they were freed by the New York courts. The horrors and injustices inflicted on African Americans as slaves in our country have been well documented. Lesser known is the important role that New Yorkers and New York courts played in chipping away at the foundation of slavery before the Civil War. This is the story of the Lemon slave rescue case. The hero who started the case in the New York courts in 1852, and the courageous New York judges and lawyers who brought
maybe not quite as compelling as the presentation for Plessy Ferguson, but you know, it certainly is historical in nature, and I got so much from it, from reading the exhibit and those kinds of things. And I hope that you could have some time to really read it as you enter into this Jackson Center, which, by the way, this is my first time being here with my law clerk, Brandon Portis, and we just marveled at how beautiful the place is. We couldn't go upstairs, although we were really kind of like compelled to sneak up there. But I was like, well, you know, I don't have Louis Napoleon to file a petition on my behalf, so I do that.
I don't think it'd be a problem.
It wouldn't be a problem. No, but it's absolutely beautiful. And the hospitality is just so warm. And, you know, you all in the south of western New York have the reputation for being very kind, and you've outdone yourself, I can tell you that now. And I can also say that this is not the last time that I'll be coming down here. You'll see more of me. And the other thing I wanted to let you know is that as the administrative judge, my phone is open and my doors are open, and if you have any issues, you're more than welcome to let me know about it. I'll be as responsive to you as I am to Judge Cass. You know, the question now is, you know, well, what do you do as an administrative judge? You know, what are your responsibilities? And, you know, I wanted to kind of point out to you that we didn't always have an, you know, Office of Court Administration. We were basically run independent of all of that. And, you know, years ago, long before, you know, me, but years ago, you know, the chief judge started thinking about having a system that would be, you know, more inclusive, to have a system that would be more reflective of the people that it served. And to get that done, they created the Office of Court Administration that would impact hiring, that would impact policy and budget and those kinds of things. And then the chief judge appointed a chief administrator. You know, we had here in the film, now resigned, Chief Judge Janet DeFiore. And Janet DeFiore hired Judge Lawrence Marks, to be the chief administrator of the state of New York. And so if you can picture that, you have the chief judge of the Court of Appeals that appoints the chief administrator, in this case Judge Marks. Judge Marks then appoints what's called deputy chief administrative judges for districts, okay? And for our district, the deputy chief administrative judge is Justice Norman St. George. And so under the deputy chief administrative judges, you have the administrative judges for particular districts. I think you have 14 districts, and we're District 8. And so at the time that I interviewed for the position, it was Chief Judge Marks and then Deputy Chief Administrative Judge Vito Caruso. They interviewed me of a number of candidates, and they chose me to serve as the administrative judge in July of 2021. It would have been July 8th, to be exact. I'm not super with dates, But then after listening to Ms. Ferguson and Mr. Plessy, I said, I better get really good with my dates. So July 8th. And so we've been serving as the, in that capacity since that time, and it's a learning process. And, and when you say, well, what does the administrative judge do? I'm learning as I go. But the beauty of it for me is I had an incredible predecessor in Paula Fiorlito, Justice Fiorlito. And she was super duper, and I'll tell you a little bit about her in a moment, okay? But essentially, my responsibility is to manage the day-to-day operation of the courts within the 8th District. And that would be from the town and village, although, something I learned as an administrative judge, the town and village judges, those courts, aren't really a part of OCA. They're not really a part of the unified court system as we know it, but they need us. They need us for resources, they need us for a lot of things, and so we have an understanding that, okay, if you are going to take advantage of our resources and our assistance, then you're going to have to at least have a willingness to play by our rules, so to speak. Brandon, I'm not giving insider information, am I? So in essence, we, I manage the town and village judges as well with respect to policy. So let me give you an example of policy. COVID pandemic and the protocols that went into effect. Protocols such as social distancing, mask wearing, all of these things that in some parts were agreed with and in others were not. Well, we really can't force the town and village judges to comply with that protocol, but under the agreement they did. Judges, we, just like you all, you have to go for CLE courses. Well, the judges, we have to go for conferences, and we have to go for seminars, and we have to do all of that. We sign in and sign out and do all of those things. If you don't, then it could be problematic. Well, if you don't, as a town and village judge, you could get removed, right? And so they comply with that, right? Well, it's my responsibility to make sure that they get the protocol, that they understand it, and that they comply with it. But I also, manage the day-to-day operations of city courts, right? Judge Panabianco can tell you, he's wonderful, so he never hears from me, but, he's really awesome, okay? And he does a wonderful job, and we're fortunate in our district to have super judges. But I have to manage the day-to-day operations, the kind of cases that they hear, whether they have to participate with off-hour youth part arraignments that Judge Cass talked to you about. Well, those are kinds of things that I have to, as the administrative judge, determine, okay? Then I manage the county courts, okay? Judge Cass is a multi-head judge, but he's also able to handle Supreme Court cases. Why? Because the administrative judge has the authority to designate him acting Supreme Court judge. So he gets to handle cases. Or Judge Hanlon, congratulations again, Judge Hanlon, who, is our Supreme Court judge. I didn't have to assign her to a particular district, but I did assign her to a particular district. She made me. So, but I did. So that's an example of that. But then it goes deeper than that. It's, funding and budget and hiring practices. And, for years, honestly, in our system, we didn't hire women for the most part. We do now. And in fact, it's gotten to a point where we probably have far more women. I can be candid with you. We do. We have far more women employed in the 8th Judicial District than we do men. Well, that's a major shift, right? The focus is to bring diversity, so we have to look at those hiring practices. Well, I have to do that. Or whether or not we're going to have people of color in a system where at one point we didn't have any people of color. When I first started in Erie County Family Court, the largest of all the family courts in the 8th Judicial District, you had 2 people of color out of 114. Okay? And so it's the purview of the administrative judge to try to change that, okay? And so, you know, those are just examples of what my responsibilities are as an administrative judge. But, you know, I'm also responsible for trying to further the agenda of the chief administrative judge as it relates to diversity practices, as it relates to, you know, the concept of implicit bias. You know, people don't like the word discrimination and discriminatory practices, right? Racism, you know, that stuff is like, ooh, right? It exists, but people are still like, oh, you can't talk about that. But people are more inclined to listen when you talk about implicit bias. Why? Because everybody can look in the mirror and say, oh, as you explain that, yeah, I have implicit biases, right? Like, here's an implicit bias, right? Some women think that guys with blonde hair are the most beautiful men in the world. Then okay, that's an implicit bias. It's not a bad one, it's just your choice. Some people, I remember vividly, did not come to work when the prince and princess, I think it was, in England, got married. They didn't come to work the next day. They were caught up in the marriage. They thought so highly of these folks. Never met them, don't know anything about them, but they had already a bias that these people were great. Okay, so that's a positive implicit bias, but then there are also implicit biases, as you all know, that are negative, right? And so I can leave you to your own imagination there, right? But so it's my obligation and responsibility to try to change that culture. And I can't do it by myself, but we have, you know, from the top down, we have policies that they want the administrative judges to further. And I get it, and it makes sense. And we've created things like, you know, justice initiatives, which you probably have all heard of at some point or another within our court system, so that we can assure that these policies of inclusion and diversity and, you know, that we can reach our goal, right? We have a policy of, you know, there can be no bullying in the courts. None, zero. If you do, you get fired for that, okay? That's a policy we have, and it's my responsibility to make sure that people understand that. You can't impose your will on employees who don't have your title, you know, where you're having personal relationships and things of that nature. So that, I hope, kind of gives you a firm idea of what I do as an administrative judge. And I suspect at some point, if you wanted to ask me a question or two, I wouldn't mind that. I would take a question. So the next part of what Judge Cass wanted me to chat about within the context of Plessy versus Ferguson and the lemon slave case and Brown versus Board and the civil rights movement is how I, you know, being the only person of color to ever serve as the administrative judge, you know, would get to this point. How did that happen? You know, and I said, sure, I can do that. I'll give you the Cliff Note version of it, and because after listening to the Plessy Ferguson, I realized it is not even close to being Homer Plessy. Let me just tell you that, okay? Not even close. So or Louis Napoleon, okay? But you know, the point is this: that I was a product of the busing, the desegregation, and the busing of children from one neighborhood to another. Like I was, like in the beginning, even though you probably all think that you can't be, you're too young for that, but I was. Okay. And why? Because, you know, as was talked about in the presentation, the Brown versus Board case was decided in '54. But do you know how long it takes to implement stuff? And especially national, like on a nationwide basis. So it took 15, 20 years to really get this stuff going. And like people don't realize that. And so here I am, you know, a part of this. I share this with my law clerk from time to time, okay? And I would get bused from my neighborhood to West Turtle Middle School, which was in the white neighborhood. They never bused white students into the black neighborhood, ever. It was always the, as they called it, colored kids going to the white neighborhoods. Now, look, I mean, I went through that. I went through my bus being bricked as we would be coming into the neighborhood and leaving out of the neighborhood. There were times when my bus that was being bricked would pull over in front of the police station, and the kids, we would all have to crawl under the seats. Like, I dealt with that. I dealt with the whole concept of walking into a classroom where you were treated differently because of the color of your skin. I never walked in a classroom and started out with an A and had to work my way down. I always walked in a classroom and started off with an F and had to work my way up. It wasn't just me, it was my friends who would have to get up extra early to get on the bus, to be bused to the white neighborhood, who would get on the bus and have to get through traffic and the rocks and the stones to get back to our neighborhood. By the time our Caucasian students, they had already been home, they've eaten dinner, they were out playing. We were on the bus, trying to get home. Okay, so I lived through that. And believe it or not, I never watched Perry Mason or any of those stories. But that experience made me want to become, of all things, a lawyer. And I never even met a lawyer until I was grown. Okay? So I go to East High School, which is now in a black community, and we don't have black teachers. We didn't have black teachers. We didn't have people who looked like me teaching us. When you look out there right now at the poster on Judge Jackson, just look at that. It says, he was no different than you. He was just like you. And then it lists the educational process, and it lists the teachers, and all of these wonderful things. And I'm standing there saying, it wasn't just like me, I didn't have that, okay? We had Caucasian teachers coming, bust in to our schools to teach us. That's what we had. And my guidance counselor made it very clear to me when he asked me, you know, well, what are you gonna do? What do you want to do? I said, I wanna go to law school. He said, no, you can't go to law school. You can't be a lawyer. You should go to art school. Because that's what you're good at. And I did. I went to art school. I went to art school at Deferred for 2 years. I incurred debt, and I also realized that the concept of starving artists was true. It was true. I looked in the mirror, I was 98 pounds, I decided, no, this is not what you want. You got no friends, you're losing weight, and you're learning how to paint. So it's not what you want. I was never gonna make any money at art, painting, and doing those kinds of things because it wasn't what I wanted, it wasn't what my heart desired. So I came back to Buffalo. And my goal was to go to school for academics and to become a lawyer and to never, ever, ever allow anyone to say to me, you can't do something. You can't do something. So I did that. Took developmental courses, I get into Villa Maria College, I graduate, I do wellness school, much to my surprise. A guy who basically had been told, you can't do this. So I go to Canisius College. Now, at the time, Canisius College was looked upon as a really good institution of higher learning. It was like the Harvard of the region, basically. That's how we looked at that. And it kind of cost that kind of money as well, I'll be honest with you. So I incurred that, but I went there. And in my senior year, I go to the dean of the pre-law program. And you know, we sit and we chat. I tell him I want to go to law school. And he says to me, you're too late. You're too late to apply. You should wait until next year to apply. And of course, I listened. And I immediately got up and said thank you and walked out. And I go to the EOP program, Higher Education Opportunity Program. Okay? It was a bill passed some years ago by Arthur O. Eve. And Arthur O. Eve is responsible for this bill that ultimately gave people who couldn't afford school an opportunity to go to college. Okay? So I go to Lillian Dudley. Lillian Dudley was the director of the program. Okay? It's how I got into Canisius College. And, you know, when I first applied to Canisius College, I interviewed with the staff in the program. And we talked, and they said, oh, you would be a great candidate. Come on in. We'll take you in our program. Senior year, Lillian Dudley. And she says to me, really? Now, I'm not going to disclose the pre-law professor's name or my guidance counselor. I know them. I remember their names. Okay? But she said, what do you think you need to get into law school? I said, well, I got my application all squared away. I'm going to have to write a personal statement to get into law school. And Lillian Dudley was, in her college days, an English major. The Lord was working. And so we wrote a personal statement. I put my package together. I put on my only suit I had. It was actually a sport coat. I go out to the University of Buffalo School of Law, to the admissions office, and I say to the lady, you know, I'm Kevin Carter. I have an application for law school. I really want to come to law school. And she says, okay, well, you can give me your application and I'll take it. I said, oh, no, I don't want to do that. She said, what are you going to do? I said, I want to speak with somebody that's on the admissions committee. She said, well, there's nobody here right now. I said, well, this is the admissions office, right? She said, yes. I said, well, then I wait. So I go and I sit over in the corner, and I can tell you, I mean, I walked in the office, there's a long little desk here, you got these seats here, or a counter, and I sat in 1, 2, 3 in the second seat. I just sat there. Okay? 45 minutes goes by, and she says, and Kevin, you know, there's nobody here. Do you want to leave your app? I said, no. She said, what do you plan to do? I said, I plan to sit here until I speak with somebody on the admissions committee. And she said, really? I said, really? She says, okay. 20 minutes go by or so. A young guy walks out of the back office. A young guy. And he says, oh, hi, I hear you have an application for admissions. I said, sure I do. He says, well, do you want to leave it with me? I said, no. He said, what are you going to do? I said, well, I'm going to leave it with somebody who serves on the admissions committee. And he says, okay. He comes back out in about 10 minutes. He said, hey, you want to chat? Let's chat. I said, sure. We go into an office. And he and we talk for about 45 minutes. And we have a good old time, okay? And I realized that through our conversation that he is a student in law school. His name is Eduardo, okay? And rest in peace, Eduardo passed. But he's in law school at the time. So we're having a really good conversation. And he said to me, Kevin, I gotta go, something to that effect. Why don't you leave me your application? And I said, I thought it was a setup. Right, guy had nothing to do. He's gonna take my application, throw it in the trash. I said, no. He said, what are you gonna do? I said, I'm gonna wait till I can speak with somebody on the admissions committee. And he said, I am on the admissions committee. I said, no, you're a student. He said, that's true. But we have students, faculty, and administration on our admissions committee. And you're going to hear from us shortly. 2 weeks, I got my letter saying that I was admitted into the law school. So I was thrilled until the week prior to school, I walked in the mailroom and saw that I had to read like 1,000 pages to be ready for this week. And I was like, I bit off more than I can chew. So I go to law school, and I do reasonably well. I mean, I really did. I had a course or two where it wasn't the greatest grade. I never flunked anything, and I had some really good grades. Okay, and you know, you in your senior year, you start reaching out to firms and those kinds of things. You know how it is. So I did that, and I was like thrilled. I got 2 firms, one in particular. I won't say the name. We talked over the phone. It was a Thursday. They needed to hire somebody right away. Right away. Quoting, we need to hire someone right away. Can you come in next week? I said, sure, I can come in next week, Wednesday. Oh, absolutely. I go in, I walk in the office, I sit for about 20 minutes. One of the partners walked out and said to me that they didn't need any help, that they weren't hiring. They never even had an interview. I just walked out the office. I graduated, opened up my own law practice, had a very decent practice, so decent that I joined a firm, Sullivan Oliveria. And Dick Sullivan is an incredible guy. And so one day, he's at a barber shop, and there's a guy by the name of Tom Reynolds, Congressman Reynolds at the time. Congressman Reynolds was looking for a candidate to fill a vacancy in Erie County Family Court, and Dick Sullivan said, oh, I got a guy for you. And I met with Tom Reynolds, became a judge over in Family Court, and for 10 years, as a judge in Family Court, I tried desperately to learn my trade. I wanted to be a good judge. I really wanted to do that. I wasn't thinking about politics. I wasn't thinking about any of that. I was thinking about being a good judge. And then, of course, I started trying to get involved, and after that, get involved in some things. I was never really given the opportunity. Janet DeFiore came along as the chief judge of the Court of Appeals. And she had a real vision. She's resigned, and I'm sure you're all familiar with it. I'm not going to talk about that, but she had a real vision about inclusion, because women were not given the opportunity to be a real part of the system. They weren't given jobs, high-ranking positions, or any of that. And so they had a real vision to include, to have diversity, okay? And so, that was good for me, to be very honest with you. It was good for me and a whole lot of people, because DeFiore started to see also that no, the diversity had to be across the board, and we would have to implement policy in order to have a diverse employees. We would have to be diverse there, okay? So they came out with a law called the Raise the Age legislation. And, I had been a judge for quite some time, had been, reversed probably in 18 years once, remanded twice, 18 years. So I knew that I had a practice when I was practicing law in the area of criminal law, and my law clerk at the time, Brandon, my law clerk, he was an assistant district attorney, okay? So now, what the legislator did, Governor Cuomo, they had an unfunded mandate, okay? And the mandate, if you read the minutes, it simply says about family court judges doing major felony cases, murder, robbery 1, kidnapping, all of these major cases, they'll just have to learn. No training. Judges who never even wanted to do criminal work would now have to do criminal work. That was our legislation. That was what the legislators were saying, okay? So I said to Justice Fiorito and Judge Griffith at the time, who was the supervising judge, look, why don't you allow me to do the youth group? Okay? He said, well, you have to create the court. I said, oh, okay. Do you really want to do that? I said, sure, there's no problem. So we got, you know, participants and stakeholders together, and I wrote a plan, 50-something page plan for the youth part of Erie County. And then I said to Justice Ferlito, okay, we've done that, I would love to be the presiding judge. She says, absolutely. Judge Griffith, absolutely. And then what we noticed is that around the state, we were getting calls from people, judges, and they were asking, how do you do this? How do you do that? What were you thinking when you put that together? How do you? And so we started being like the hub for folks to call, and we helped people create their youth park throughout the state. And also, we would write decisions. Like it requires that you write a lot of decisions, so I wrote a lot of decisions in this area of criminal law, and that we refer to as raise the age. And so the judges from around the state would read my decisions, and they would use my decisions, just like I would use other judges' decisions, okay? So, you know, after that, Judge Griffith and Justice Ferlito seemed to be pretty pleased with that. And I said, well, if you're really pleased, because Judge Griffith was retiring, I said, if you're really pleased, would you consider me for the supervising judge's position? And Justice Ferlito said to me, really? I said, yes. She said, thank you. I was hoping you would apply. I said, oh. So, you know, I became the supervising judge. And as fate would have it, the pandemic hit. The pandemic hit, and we have COVID. And now all of a sudden, while we're downsizing, Justice Ferlito brings me in to really work with her side by side in addressing COVID and managing the courts. And I began to meet people, like, for example, Vito Caruso, who at the time was the Deputy Chief Administrative Judge. So I met him. And then I met Judge Marks, the Chief Administrator, in my capacity as a supervising judge. And so, you know, time went on, and I worked with Justice Ferlito. We did the best we could to address the COVID pandemic. I think we did a decent job. And then ultimately, she resigned. And, you know, thought it would be a great idea if I would consider applying. And I applied. And when I interviewed with Judge Marks and the DCAJ Caruso, you know, I was no stranger to them. I was no stranger to them because at some point in time, people believed that diversity and inclusion was a positive thing. It was a good thing. It wasn't a bad thing. And they also learned that, wait a minute, you can't judge a person by the color of their skin. You can't judge their intellect by the way they look. You know, there are some highly intellectual, you know, IQ folks that off the chart, and they walk in here and you think they were bums. Okay? So you can't allow your implicit biases to control the outcome. And if you do, you could miss out on a thing. I'm not saying that I'm the thing. I'm just saying that if you do, you can miss out on some things. Okay? And I know that to be true because that's what Judge Marks said. That's what he said when he said, I want you to be the 8th Judicial District Administrative Judge. I want you to do that. Okay? And he was very candid with me about that. And so, you know, here I am now. I've been very fortunate. I've had the opportunities that weren't presented to people who had gone before me, who were probably far more talented than I am. But I'm here. That's what Drake says. How many of you have ever heard of Drake? Dude, don't be afraid to raise your hand. Drake is an African American who happens to be a musician. And in one of his songs, he says, I started at the bottom, but I'm here right now. And it's true. And so, you know, I have so many people to thank for that. And certainly I want to thank all of you for listening to me. You didn't have to, but you did. You stuck with me through it. I really appreciate it. And I hope, Judge Cash, you're not offended by the fact that I wasn't quite as brief as you told me I should be. But I do really, truly appreciate the opportunity to come down and share with you.
Wow, that was terrific. Thank you, Judge, and we all learned an awful lot today. We all learned an awful lot from this morning's activities, and a special thanks to Keith and Phoebe for making this an extraordinary morning for us here to learn so much about history. By the way, we'll learn a little bit more history before this day is done when we go on an Elby and Tourget role. And to Judge Carter, thank you. Judge Cass for extending the invitation, and Judge Carter for accepting. Brandon, thank you for bringing them down. I appreciate that so much. And we could stay longer, but Judge Panabiango says, will I be back by 1:30, so as not to offend Judge Carter. So with that, we stand adjourned.
Great job.